Okay, this is People of the State of Michigan versus Anthony Palmer, docket numbers 21-133FH and 20-871FH. I'm informed this is a plea on one count on each file. And Mr. Palmer, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Mr. Palmer, you have the right to be represented by an attorney. You are represented by Mr. Yang, who's present. And Mr. Yang, if I said that correctly, it is a plea to count, I guess we'll start with the lower number first. In docket number 20-871, it's a plea to count 3, and then in the other file, it's a plea to count 2. Is that correct?
Correct, Your Honor.
And then will you waive reading of the balance?
Yes, Your Honor.
Okay, your audio's real bad, Mr. Yang. I don't know.
Let me try that. Is that a little better?
That's better.
Had the mic in the wrong position.
Yes, sir. Ms. Polda, would you read the 2 counts then, the one in each file?
Yes, Your Honor. On the amended information on docket 2871FH, State of Michigan, County of Ingham, in the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about September 11th, 2020, at 6820 South Cedar Street in the city of Lansing, Ingham County, the defendant did in count 3 make an assault or an assault and battery upon Kelly Gamblin, an individual with whom he had a dating relationship contrary to the law. Take notice that the defendant was previously convicted of assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating the law on or about July 11th, 2017, and by violating that same law on or about August 25th, 2020. Therefore, upon conviction, will be sentenced to an enhanced sentence, or subject to an enhanced sentence, that being making this crime domestic violence third offense punishable by up to 5 years and or $5,000. A consecutive sentence may be imposed if it was done in a place of confinement. That case was done against the peace and dignity of the state of Michigan. In docket, on the information, in docket 21-133FH, State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about December 30th, 2020, at 419 West Cesar E. Chavez Ave, City of Lansing, Ingham County, the defendant did in count 2 make an assault or an assault and battery upon Kelly Gamblin, a resident or former resident of his household, and or an individual with whom he had a dating relationship contrary to the law. Take notice that the defendant was previously convicted of assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or knowingly assaulting a pregnant individual by violating the law on or about July 11th, 2017, and violating that same law on or about August 25th, 2020, and therefore upon conviction will be subject to an enhanced sentence under the law, that making this domestic violence third offense punishable by up to 5 years and or $5,000. This was done against the peace and dignity of the state of Michigan.
Mr. Palmer, you're being charged here with domestic assault and battery third offense, 1 count or 1 charge in each file. Those are each felonies and each punishable by up to 5 years in prison. And if you were on parole at the time you committed the offense, it would be a mandatory consecutive sentence. Have you had enough time to talk about these charges with your attorney?
Yes.
Do you understand the charges against you?
Yes, Your Honor.
Do you have any questions about what we're doing?
No, Your Honor.
And how do you want to plead, Mr. Palmer?
Guilty.
If your plea of guilty is accepted by this court, it means you won't have a trial of any kind, and you'll be giving up the rights that go along with the trial. I'll go through those with you. You'll be giving up the right to a trial by jury. If you didn't want trial by jury, trial by judge. You'll be giving up your right to be presumed innocent until proven guilty, and to require the prosecutor to prove your guilt beyond a reasonable doubt. You'll give up your right to have the witnesses against you appear at the trial and to be able to cross-examine them, as well as the right to have this court order any witnesses that you might have to appear at the trial. You'll give up your right to remain silent at the trial and not to have your silence used against you, or in the alternative, your right to testify yourself at the trial if you wanted to. Also, there's a couple of things that are different about appeals when you plead guilty. One is that when you plead guilty, you don't get an automatic right to have the higher court hear your case. Instead, you have to ask them to hear it, and they would have to agree to hear it. And the other thing that's different is that when you plead guilty, there are a lot of issues you may not appeal. Unlike someone who goes to trial and gets convicted, they can appeal pretty much everything. Do you understand those rights?
Yes, Your Honor.
Has anyone, or also, if I accept your claim, it means you cannot come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Yes, Your Honor.
It also means you cannot come back later on and try to say that it really wasn't your own choice to plead guilty today. Do you understand that?
Yes, Your Honor.
Is there a plea agreement, Ms. Polda?
Yes, there is, Your Honor. On docket 20871FH, defendant will be entering a plea to count 3, which is the domestic violence third offense. In exchange for that plea, the people will move to dismiss counts 1 and 2, as well as habitual offender notice. In docket 21133FH, defendant will be entering a plea of guilt as to count 2, the domestic violence third offense. In exchange for that plea, the people move to dismiss count 1, as well as the habitual offender notice. There's also a sentencing agreement under People versus Kilbrew that if the court imposes any upfront incarceration, that sentence shall not exceed 12 months.
And Mr. Yang, is that a full and complete statement?
It is, Your Honor.
And Mr. Palmer, is that your understanding of the agreement?
Yes, Your Honor.
And do you agree with it?
Yes, Your Honor.
There is an agreement here about your sentence, and that is that if there's upfront jail time, it would not exceed 12 months. If for some reason I decided not to go along with that, I'd tell you before I sentenced you, and I'd give you a chance to take back your plea and start over if you wanted to. You got all that?
Yes, Your Honor.
Has anyone promised you anything else in order to get you to plead guilty that hasn't been said here right now?
No, Your Honor.
Has anyone used any threats to get you to plead guilty?
No, Your Honor.
Is this your own choice?
Yes, Your Honor.
And are you pleading guilty because you believe you are in fact guilty of these offenses?
Yes, Your Honor.
Okay, let's start with the one that happened first in time, and that's on or about September 11 of last year. Tell me what you did regarding Kelly.
We got into an argument, a heated argument, and I shoved her.
You shoved her?
Yes.
And did you do that on purpose?
No, Your Honor. Yes, Your Honor. I got a little heated, and I
Okay.
shoved her.
Okay. And Kelly is someone that you at the time had a dating relationship with, is that right?
Yes, Your Honor.
And this happened at 6820 South Cedar Street in Lansing, Ingham County?
Yes, Your Honor.
Okay, let's talk about the second one then. This was the one on December 30th, on or about December 30 last year. And tell me what happened on that occasion.
Once again, we got into an argument, and I shoved her again.
And again, you did that on purpose? In other words, it wasn't an accident. You didn't bump into her by accident. You shoved her. Is that what you're saying?
Yes, I shoved her, Your Honor.
Okay. And then that one happened at 419 West Cesar Chavez Avenue in Lansing, Ingham County. Is that right?
Yes, Your Honor.
Okay. Has the court complied with MCR 6.302, Ms. Polda?
Yes, Your Honor.
Mr. Yang?
Yes, Your Honor.
Are you aware of any promises, threats, or inducements other than those already placed on the record, Ms. Polda?
No, Your Honor.
No, Your
Mr.
Honor.
Yang? The court finds the plea is understandingly and voluntarily made without undue influence, threats, or promises of leniency. It is an accurate plea, is supported by the testimony. The plea is accepted. Sentencing is Monday, April 26th at 3:45. Mr. Yang, is that okay for you?
That works for me, Your Honor.
Okay, so Mr. Palmer, is it okay with you if we do the sentencing the same way instead of bringing you to the courthouse?
Yes, Your Honor.
Okay, then we'll do it by Zoom from the jail on April 26th at 3:45. And you should be aware, Mr. Palmer, that the probation department is going to set up some kind of a remote interview with you in order to use it for the report that I prepare for sentencing. So you should just know that that's coming. And
Okay.
if you don't have any questions, we're all set. Do you have any questions?
Just for my lawyer, I was trying to see something about bond.
Yes, Your Honor. We'd like to address bond briefly if the court would allow.
Go ahead, Mr. Yang.
Thank you, Your Honor. As I mentioned a little bit earlier when we were off the record, Mr. Palmer has been in the receiving due to his medical issues. I don't think that the jail is equipped to deal with the medical issues that he has. Your bond that you set on his 20871 case was increased to $20,000 cash surety. I would ask that you consider revisiting bond and lowering bond to give him an opportunity to potentially bond out. Like I said, the major issue is the medical, and without going into too much detail as far as his medical record, at this time, the jail is not equipped to deal with the medical issues that he has. So that would be the basis of the request for. I know that it was just recently increased, but any reduction which would allow Mr. Palmer an opportunity to be out would be appreciated. I think it would have to go as far as a PR bond, but if you would consider any reduction, I would appreciate it. Thank you.
All right, thank you. And did the people wish to be heard?
Thank you, Your Honor. Defendant now stands in front of Your Honor, having been convicted of 2 assaultive felonies against the same person, his girlfriend, which I understand has recently given birth to their shared child. I don't think that this defendant is a good candidate to be out on bond at this point in time. Defendant, as you may remember, did recently stand before Your Honor and admitted to a bond violation, which involved the new case that recently came up and he has pled to today. Because of the concerns with the violations of his bond, the violations of the no contact order, we would ask that Your Honor keep the defendant in custody at this time. His Killebrew agreement is, though not a prison agreement, is for an extended period of time, and for his placement in the jail right now, he is gaining credit toward that sentence. Thank you.
I'm not willing to change the bond at this time, in that there was a previous violation of bond, and it would appear that Mr. Palmer was convicted of a domestic assault and battery in August of last year, and he just pled to one in September of last year and then one in December of last year. I don't recall if I was ever told of what the medical problem is, and I understand why you wouldn't want to go into it today. But if there's really something that, rises to the level of overcoming the facts that I've already laid out about why he's in custody, then Mr. Yang, you can submit it to me. And I certainly don't want anyone to suffer any kind of a life-threatening or serious medical condition if they can't get treatment at the jail. But you can submit it to me and of course the prosecutor as well. And I'll consider it, but I would have to know that he has like a specific medical appointment or a specific treatment date or something like that in order to release him from the jail. And I'd of course have to know more about what the medical condition is. But, again, my job is not to make people suffer or sick. It's to protect the community. And at this point, that weighs more strongly in favor of keeping them in custody.
Understood, Your Honor. Thank you.
Thank you. And Mr. Palmer, you can tell them then at the jail there that you're all done so that they can use the room for someone else. Thank you.
Thank you. You have a great day.
You too.